Topic 9, Lesson 5. Okay, now we look at profit companies. This is a private company, a public company, and a state-owned company. What is a profit company? They aim to make profit by selling products or services. So I think that one is a pretty obvious one. It is important to recognize that companies vary in size, turnover, and in the number of shareholders. We cannot differentiate between businesses based only on the number of shareholders, as some very large companies have a small number of shareholders. In South Africa, all companies need to comply with the terms of Companies Act. The following are profit companies: a private company, a public company, and a personal liability company. Characteristics of private, public, and personal liability companies. There are the three main forms of profit companies. Public companies have an additional option of issuing shares freely to raise capital, so they can sell shares to the public, and then in that way the public pays for the shares and therefore the company makes money. They need only a single registration document. A memorandum of incorporation is required to register, so they literally need one piece of document to register. The Memorandum of Incorporation sets out rights, responsibilities, and duties of shareholders, directors, and others involved in the company. Okay, private companies. It is used to be limited between 1 and 50 shareholders, but under the new Companies Act, any number of shareholders is allowed. So it's 1 to infinity. The company name must end with Proprietary Limited or Pty Limited. Capital that is invested is divided into shares, which are bought by the company founders, who each then own a portion of the company. Articles of association limit the right to transfer shares. Okay, so meaning you cannot simply transfer your shares. Let's say you have 20 shares in the business. You can't just transfer it to your brother or sister. You need to go through a few loopholes before you can do that. We will go through that now. Okay, shares cannot be freely sold to the public, only if shareholders do not want it. The minority of shareholders are able to call a general meeting. An example of a private company is Woolworths. Okay, I know we only talk about Woolworths or Woolies, but if you go look at the website, it says Woolworths Pty Limited. Okay, now we look at public companies. It is usually very large businesses. The name ends with limited or Ltd. It is called public because any member of the public can buy shares. Used to have at least 7 shareholders to begin with. Now they can have a minimum of 1. The maximum of number of shareholders is determined by the issued share capital. Okay, so if they only issue 50, then that's the number of shareholders that you can have. To acquire capital by issuing shares to the public, so it's easy for them to get money. If they need money, they can simply issue shares, people can buy it. Shares can be sold or given from one person to another without restriction. So you can decide if you want to give shares to your brother or sister or friend in such a business. Now, example here is Absa Bank Limited. So did you know you can buy shares in Absa? Personal liability companies. They must meet the criteria for a private company, and its Memorandum of Incorporation should state that it is a personal liability company. It ends with the word incorporated or the abbreviation Inc. It is similar to a private or public company, but they are usually associations of professionals such as lawyers. Directors and past directors of a personal liability company are jointly and severely liable, together with the company, for any debts and liabilities of the company. Okay, so this means that in some cases, if the company cannot pay off all the debt, the banks also can move forward and take some of the belongings of the owners. The board of a personal liability company must include at least one director. An example is Veritas Inc. It is an accounting and auditors firm that we have here in Polokwane. Okay, now the advantages of private, public, and personal liability companies. The principle of limited liability applies to companies. Each shareholder of the company loses only the amount that he or she has paid for shares in the company. It has an unlimited lifetime, so if somebody steps out, the business still continues. Greater access to financial resources, meaning it is easy to raise capital. They are in the position to appoint skilled and knowledgeable managers to help the business flourish. They have a business rescue scheme, which means if they struggle financially, creditors need to wait until the company is fully operational again. Okay, so this is like a backup plan that creditors really need to wait before they can just simply start making a case against you to pay off the debt. Law regarding participation of shareholders has changed, which means shareholder participation at general meetings has been modernized, and shareholders are allowed to participate outside the meeting. Okay, which means they do not need to sit in the same building to have a meeting. They can use Zoom or Skype, etc. Now, the disadvantages of a private, public, and personal liability company. They have to comply with many legal requirements when they are established and during the lifetime of the company. The tax burden may be greater than in the case of other forms of ownership. Okay, so they pay a lot of tax. The board of directors could be less personally involved in management than partners would be. Okay, this means the board of directors can sit throughout South Africa. They do not deal with customers. They do not know what's going on directly inside the business at the lowest form of management. For example, they only care about the big figures and the big numbers. High costs are involved, such as establishment fees, so you pay a lot to open or register such a company. Little personal contact between shareholders and customers. The director may become liable for losses suffered by the company as a result of that director making an unlawful decision. Okay, so if one director makes a mistake, they steal money or they launder money, that director alone can become liable for the losses suffered. Private companies cannot freely sell shares to the public. And then the transfer of shares is also restricted in private companies, which I already explained to you. Okay, I hope you understood that. Please do activity 5 on page 119 for me. Please stay up to date with your notes. Please make sure it is in your book. Please make sure you do the activities.